This is Juli Saitz from HKA Consulting, and you are listening to the IP Fridays podcast.
Hello, and welcome to this episode of IP Fridays. Our names are Ken Suzanne and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
Welcome to episode 132 of IP Fridays. Today's interview guest is Juli Saitz, and my co-host Ken Suzanne is interviewing her about damages and royalties. She's an expert on contract and royalty compliance and has helped her clients to get millions of dollars in royalties and damages. So I'm very much looking forward to hearing this interview. But before we jump into the interview, I have news for you. The EUIPO has started an initiative called Ideas Powered for Business with the main slogan, Make Your Idea a Success. The link to the website is in the show notes, and the EUIPO wants to educate and help companies to make the best of their business by protecting their ideas with different types of IP rights such as trademarks, designs, and patents. Also, the USPTO welcomes Derek Brandt as a deputy director. He is helping Kathy Vidal to run the USPTO. Also, Montenegro is on its way to become the 39th EPC contracting state. Starting from 1st of October 2022, European patents can be validated in Montenegro. Also, the UK IPO has issued an interesting guide called Licensing Bodies and Collective Management Organizations. In this guide, it tells the readers how licensing bodies and collective management organizations can agree licenses with users on behalf of owners and collect royalties the owners are owed. Now, let's jump into the interview of Juli Saitz with Ken Suzanne.
Our guest today on the IP Fridays podcast is Juli Saitz. Juli is a partner with the firm HKA and handles forensic accounting and commercial damages issues for her firm's clients. Juli has more than 20 years of experience providing forensic accounting, financial, and economic analysis with respect to investigations and commercial damages. This includes providing expert witness testimony to clients and their counsel in litigation and forensic investigation matters across a number of industries, including financial services, consumer products, real estate, aerospace, manufacturing, fashion, retail, luxury goods, and entertainment. Juli's expertise in IP matters includes contract and royalty compliance issues, and she has assisted clients ranging from individual authors to multinational corporation licensors. Her work has included developing and implementing royalty compliance programs and performing audits of licensees around the world. Juli has also helped her clients recover millions of dollars in royalties and damages related to licensed copyrights, trademarks, and patents. Juli, welcome to the IP Fridays podcast.
Thank you so much.
Juli, what is your background and how did you get into working in the forensic accounting expert witness space?
Sure. Well, I got an undergrad in accounting at NYU, and as many young people find themselves in a situation, I really had no idea what I wanted to do with my life. I knew I loved accounting and the language of accounting, but as I looked around at the typical audit and tax jobs that were out there, I was not interested in those at all. And I happened upon a job posting in the career services office pretty late in the game as I was waiting for audit offers from the big 6 accounting firms at the time, now big 4. And I saw this listing for forensic and litigation practice, and it sounded interesting to me, and forensic accounting sounded kind of cool. I joke with people that it's not that cool. It's not like CSI or anything, but it's really the the process of figuring out the numbers. So I actually interviewed with the firm. It was Coopers and Lybrand, and quickly became PricewaterhouseCoopers, and joined a practice working on all kinds of things that were somewhat accounting related, but special projects, so to speak. And so I worked on a divorce for a very famous Broadway producer who was divorcing the same woman for the second time. And we were mutually appointed by the court to help figure out the numbers. I did large SEC investigations. And then I quickly realized that I liked the litigation side of the business a little bit more, because you could see a project from start to finish, as opposed to a large scale investigation where you might get a call saying, "Hey, Julie, we need your help in Kansas City. The project's only going to be 6 weeks," and you would end up being there for 9 months to a year. Whereas the litigation projects, you might go to the attorney's office for a couple of days to look at actual paper documents in the old days, like we used to do. Mm-hmm. And within litigation, I started working with folks that did intellectual property disputes. So I really learned IP first through patents, and then got into working with copyrights, trademarks, trade secrets, sometimes trade dress, and started testifying on my own on those types of matters.
Julie, how do you work with attorneys in the context of intellectual property?
Sure. So I work with attorneys in a variety of capacities. The first thing that comes to mind is if an attorney is looking for an economic damages expert, and an attorney will call me because they either are in the middle of a dispute and need an expert, they're contemplating filing a complaint, or they've just been served a complaint. And so my role is typically to work with the attorneys, go through the materials, prepare an expert report, testify at deposition, and if it gets far enough along, ultimately testify at trial. And I do this in international arbitrations, domestic arbitrations, and commercial disputes here in the US. Sometimes I help attorneys, and I like to do this, with the discovery process. And so in that capacity, I can help attorneys draft discovery requests for fact discovery. I can help attorneys through taking depositions of fact witnesses who have knowledge about financial information. And I really like this because it's tough as an expert if you are brought in late and you're stuck with what's already been produced in fact discovery. Whereas if we can come in early, we can help with the strategy and help get the right types of documents. And I think what's really key here is that when you're in an IP dispute, the intellectual property might relate to one component of a product, or a trademark only on certain products, or copyright in, let's say, a song. And entities don't necessarily keep financial information at that level. And so it's not enough to say, to request from the other side all of their financial information related to X. And so as an expert, we can kind of help craft the questions and give alternatives of ways we could get at the information, which is really helpful for the expert to ultimately put together the analysis. Mm-hmm.
Now, you mentioned damages. How are damages different for the different types of IP from what you've seen?
Sure. So, there's general buckets and there's nuances with each one. But for patents, generally the rule is that you can get your lost profits as the patent holder, but in no event less than a reasonable royalty. And so lost profits are a lot less common than they used to be in the patent world, because there are certain tests to prove that you as the patent holder would have made actual sales, and those sales were lost due to the acts of an infringer. So a lot of times today, you have what we call a non-practicing entity who is asserting a patent. They would never make those particular sales, and so the default is a reasonable royalty. copyright and trademark, while they're governed by different statutes, so copyright's governed by the Copyright Act and trademark by the Lanham Act, have pretty much the same remedies, and they're a bit broader. So for both copyrights and trademarks, plaintiffs can get their actual losses. Now that's really broad. What is their actual loss? It could be lost profits. It could be a lost royalty stream. It could be some kind of economic harm that they incurred as a result of an infringer's actions. And then in some cases, there are statutory remedies for copyrights, and in the case of trademarks, counterfeiting. The other side of that for copyright and trademark is defendant's profits. And so a trademark copyright owner can essentially disgorge the infringer's profits, which means whatever that infringer made on the infringing, or I guess we could say accused sales, the plaintiff can claim those profits. And it's interesting in calculating that both under copyright and trademark statutes, the plaintiff need only prove the infringer's sales. They don't need to prove any cost. We can get into that a little more. Typically, you will include the cost, but really the only burden for the plaintiff is what the infringer sales were in those cases.
Mm-hmm. And can you give us an example of some of the issues you faced in calculating the damages in an intellectual property case? Any obstacles that you've come across when you're going through that process?
Sure. I mean, I think we touched on this before. One of the main obstacles is the availability of information. Mm-hmm. So as you can imagine, IP is unique, and unless it's an entire company is infringing, all of their products are accused of infringing, you can't necessarily take the income statement from that company and figure out what the damages are. So I think that one challenge is getting the right information. I've done some cases with semiconductors, and it has all kinds of semiconductors in the sales information, and only, a small fraction is infringing. And so trying to figure out which one is infringing and which one to calculate damages on. The other issue that comes up in all types of IP disputes is apportionment. So there's a lot of case law around apportionment in the patent world. Not as much in copyright and trademarks, but really, what portion of the product is at issue, and how do you get down to the damages for just that infringing portion? And so a simple example would be you have a plain white T-shirt, and then you have a T-shirt with a mark that is accused of infringing. And if there's a differential in the prices of those products, you can probably say, okay, the one with the infringing mark costs $5 more, than the damages attributable to that T-shirt are probably an extra $5. This is overly simplistic, but in other cases, it's harder to figure out what the damages would be, because what's driving the sale? Is it the whole product? Is it the infringing mark? Is it the infringing feature? There's a lot of issues with that experts need to take a hard look at when putting together their numbers.
Mm-hmm. And besides writing reports and providing testimony as part of your job, how can financial experts help IP attorneys in day-to-day practice and issues?
Well, one thing besides helping with discovery requests is I think that we can help attorneys manage their clients' expectations sometimes. Mm-hmm. And this works for both plaintiffs and defendants. The attorney has a close relationship with the client. The client often, if they are an IP owner, has very strong and emotional thoughts about their IP ownership. And that's not to say it is wrong, but they might have a certain value in mind. And at the end of the day, if an expert doesn't have the documentation or the support to get to a number that might be in a client's mind, we can kind of play good cop, bad cop and say, we just can't get there. And that can kind of help the attorneys sometimes manage their clients' expectations, because I've been in a number of situations where a client really believes something is worth a certain amount, and it very well may be, but an expert doesn't have enough information to go out there and say that's what it's worth. A credible expert, I'll say, right? There's all kinds of experts. There's overly conservative, there's overly aggressive, but I think we can help manage client expectations. I think we can also help just with the strategy. So, I had a dispute earlier this year. It was an international arbitration, and it was on Zoom, but we had the entire trial team for our side in one room. And so we had 4 different attorneys, we had client representatives, we had myself, and we had an industry expert. And just having all these smart people in one room, strategizing and putting together closing arguments really helped, because I brought a different perspective than the attorneys had, kind of as an outsider with a financial background. So I think, experts can really help with the strategy, and attorneys can run things by experts that might not be financial related, but say, how does this land to you as a non-technical person or somebody that doesn't live and breathe in this industry every day?
Mm-hmm. You mentioned that you used Zoom for that case that you were handling. How has the pandemic impacted your job, and what do you see as some of the changes going forth in the years to come as a result of the pandemic?
Yeah, in the beginning, everything slowed down like it did for a lot of people in litigation, and that was a little unnerving. And now it's really picked back up. I like Zoom depositions because I don't have to, my whole day is not spent getting ready, traveling, having the nerves, all of that stuff. So it is kind of nice to do a deposition by Zoom. But I did have to travel twice over the summer for jury trials, and then this hearing I had. And I really think that you can't replace the benefits of being in person for some types of hearings and testimony. I just think you get a better result working with attorneys face to face and working with the whole team, because you wouldn't have the same kinds of conversations and sidebars that you do in person. That just doesn't happen on Zoom. But in terms of my overall practice, I've been very busy. I am more efficient at home. Now I look back and think, why did I travel, in an hour and a half each way to go to an office to try and read depositions or write a report, and people are coming into my office? So I think a lot of us in different professions have realized that. So it's good and bad. I mean, I miss walking down the hall, knocking on a colleague's door and saying, what do you think of this issue? Or have you seen that? But we're all getting better with Zoom and Teams and other types of platforms. Mm-hmm. So in some ways, I've become more efficient. Sometimes I'll just put a block on my calendar that says I'm busy, right? And then I'll say, okay, I have 2 hours to work on a report.
Sure.
So I think moving forward, it will be a hybrid. I can't imagine ever going into the office 5 days a week. And I think, I don't know, attorneys might disagree. I think Zoom depositions are fine. But I think for, real testimony and trials, you have to be together with the team. I just think you lose a lot if you're not.
Yeah, I agree. Julie, let's talk best practices. What are some of the best practices you can share with our listeners based on your experience in working in IP disputes?
So I think that really one best practice is to, if you're an attorney, consult with experts early on in the process, because like I said, we can help manage expectations. We can tell you if there's really what the numbers are pretty early on. Or, obviously there's going to be a lot that goes into writing a report and supporting it. But, we can kind of help figure out if a claim is worth it or not. I often joke that I have a sense of where the damages are going to be within the first week or so. Now, there's a lot of work to actually get there, and sometimes I'm not right every time. But I think hiring your experts, or at least talking to them early. And I have a lot of clients that come to me that I've worked with over the years and ask me in the very early phases of a dispute what I think. And I'm not asking for an engagement letter or running the meter. I'm happy to consult with people. So I think that's a best practice. I think working with an expert where you know their team, and an expert doesn't need to have testified, 100 times. I think the times are changing. People are looking for more diverse experts, younger experts who are going to have, a personality that resonates with the jury. I think getting back to knowing your expert team, I've worked with a team for a number of years, and the senior person, who I'll call one of my lieutenants, knows what to protect me from and what not to protect me from. So if I'm working with an attorney, they can run it by this individual. They can run a thought by an individual and say, should the expert, hear that? What do you think of this analysis? Because it's important to know that once you're disclosed, everything is essentially discoverable. So to have somebody working on the team who can shield me from certain things is helpful, right? There's certain things that attorneys don't know if I should know or not. And then if I have a senior person that can listen to it, I'm a little bit protected in that way. I think communicating with goes both ways, but communicating with outside counsel is really, really important and a good best practice. I have a recent case where there's been very little communication with the attorney, and I issued a report and they didn't really have time to review it. I just felt like I need somebody to check this, right? Because attorneys may have a way that they like the footnotes formatted, or I might be saying the accused products and they want to say the infringing product. So little things like that. I think communication is really key. And the other best practice is for experts, and this has changed, but being careful with drafts. So it used to be that all drafts were discoverable. A lot of those rules have changed, or counsel will stipulate that drafts aren't discoverable. We're still pretty careful about keeping one live living version of the report on a network and not passing drafts around, and not, keeping paper copies and not having a bunch of copies in email. I think that's important. At the end of the day, if somebody wants to depose you on a bunch of different versions of a draft, I think it's kind of a waste of time, but it's kind of embedded in me from my earlier days to be careful with what you say in email, what you put in draft, what's flying around out there.
Julie, we're nearing the end of today's episode, but I have a question for you, and that is, if one was looking to hire an expert, what are some of the things that an IP attorney needs to look for when they're choosing an IP expert?
Sure. Well, the first thing I would start with is asking your colleagues if they've worked with an expert. I think if you're looking for an IP expert, somebody with IP experience, it is important because there are special rules around, damages and the certain types of remedies. And so somebody who has done that before knows what goes into a report. I don't know that it's necessary that someone has testified before if they are senior enough in their career and have written reports and are comfortable testifying. And as an attorney, you'll get a sense if that person would do well on the stand, so to speak. The other thing you can look for is, have they had a Daubert challenge? Now, it's different than it was 15, 20 years ago. A lot of people in the IP space do get challenged, and it's just, it's written into scheduling order sometimes. Like the Daubert motions are written in, which didn't happen before. And so check if your expert or your potential expert has had one, and then just ask them about it. I don't think it's a career ender like it might have been some years ago. I haven't had one, and I joke I do a lot of arbitrations, and it's nice because you can't get challenged that way. But I think it's something worth checking, right? And also ask, does your expert do primarily plaintiff work, primarily defense work? Is it a mix? That's something to know, to get comfortable with. And then in terms of industries, I often find that attorneys are looking for a unicorn, right? You've testified in these industries, you've worked in this industry, you've calculated this specific type of damage. I don't know that attorneys are always going to find that. And if you have a smart person, industry may not matter as much unless you're in something really specific, like you're doing pharmaceutical litigation and Hatch-Waxman. I wouldn't put myself out there as somebody who does that, but there are folks that do. However, if you're talking about one particular consumer product that an expert hasn't, done something on that consumer product, it probably doesn't matter.
Mm-hmm. Juli, I want to thank you for spending time with us today on the IP Fridays podcast. How can our listeners get in touch with you if they want to talk further?
Sure. So you can probably find me on LinkedIn pretty easily, or I am at HKA Consulting, and my email address is Juli Saitz at HKA.com. It's JULI S like Sam AITZ at HKA.com. So I like to throw people off. It's Juli without an E.
That's right. Well, Juli, thanks again for spending time with us on the IP Fridays podcast.
Thank you so much. I appreciate it.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.